There is an unwritten law in America. The Constitution actually identifies it by name, but only in passing, and only once. This unwritten law is known as common law. And oddly, U.S. courts claim that the way England practiced it in 1791 should define what rights Americans get today. English common law and a king's rule stopped a widow from getting justice for the death of her husband, and it still stops people today. But there is a way that the courts bury the fact that they're even using this king's rule. It's subtle, but once you see it, you'll be able to spot it a mile away. We'll cover all this, and I'll do it by simply telling you a few stories. With one involving mystery cancers springing up among the crew of a John Wayne movie, with the cancer's connection to secret radioactive experiments only coming known years later, and as Congress would be forced to admit, impacted way more than just a film crew. Lieutenant Rudolph Ferris is stationed at Pine Camp, later renamed Fort Drum, in upstate New York. He's a young officer, married, serving his country, a decorated World War II veteran who parachuted into Normandy on D-Day. Before dawn on December 10th, a fire rips through his barracks. The Army had quartered him in a building with a defective heating plant. No adequate fire watch. The heating unit causes fire. Lieutenant Ferris tries to escape. He dies in the barracks. His widow, Bernice Ferris, is left alone with an infant son. She sues the government. She accuses the Army of negligence, the kind of negligence that, if a private landlord had done it, would make them liable. In 1946, Congress had passed the Federal Tort Claims Act. The act proclaimed that the United States shall be liable in the same manner and to the same extent as a private individual under like circumstances. A private landlord would be liable for a defective heating system that killed a tenant. The case reached the Supreme Court in 1950. Justice Robert Jackson wrote the opinion for unanimous court. The court ruled against Bernice Ferris. According to Jackson, there are few guiding materials for our task of statutory construction. Congress hadn't carved out exceptions. The statute had none. So the court actually saw this as a problem, and they created an exception. Jackson continued, "We know of no American law which has ever permitted a soldier to recover for negligence against either his superior officers or the government he is serving. No remedy for negligence, no recovery for wrongful death." Jackson cited precedent, with one precedent, surprisingly, coming from England. While the political theory that the king could do no wrong was repudiated in America, a legal doctrine derived from it, that the crown is immune from any suit to which it has not consented, was invoked on behalf of the Republic and applied by our courts as vigorously as it had been on behalf of the crown. So Jackson's words dismiss the king can do no wrong. America repudiated it, he says. But then he states that the same principle of immunity for the king is okay because it's invoked by the U.S. government. No king, but we'll take his power. Thank you very much. So where does this doctrine come from? And why is America even using it? When I was reading this, I was surprised. I was thinking to myself, didn't we win the revolution? The story of this begins centuries before the Constitution, not in a search for liberty, but in a king's search for gold and control. England, 1154. Henry II becomes a king of a realm that barely deserves the name kingdom. England isn't unified. It's a patchwork. Some areas follow Anglo-Saxon traditions, going back centuries. Local assemblies where freemen gather to settle disputes, where custom is passed down through memory, where justice belongs to the community. Others follow Norman customs brought over after 1066, when William, Duke of Normandy, crossed the English Channel, defeated the English king at the Battle of Hastings, and claimed the throne for himself. William replaced the Old English lords with his own men. French-speaking nobles now ruled over English-speaking peasants. Norman landholders brought their own way of doing things. Rigid feudal hierarchy, land held at the pleasure of the crown. Nearly a century later, England still hasn't settled the question. Whose law applies? Saxon custom or Norman command? It depends on where you stand and who your lord is. Local lords hold courts and dispense justice according to their own rules, their own interests, their own whims. For a peasant with a land dispute, justice depends entirely on geography. Henry II looks at this fragmented mess and recognizes two things. First, he doesn't control it. Local lords have power. Local customs have legitimacy. The king's authority has limits. The second realization, there's opportunity. So King Henry creates a system of royal courts that derive their authority directly from the crown. He sends royal judges out on circuits throughout the kingdom to hear cases. He offers something the local courts often can't, writs, standardized legal procedures you could purchase to bring your case before the king's justice. And people pay for them. Not because they love the king, because royal courts become viewed as more predictable than baronial courts. Because a standardized writ is better than begging your local lord for fairness. And it also doesn't hurt that the king's judges travel with armed enforcement. These royal judges start doing something remarkable. They write down their decisions. They cite previous cases. They create precedents. Case by case, decision by decision, they're building a body of law that's common to the whole kingdom. And yes, initially controlled by the king's judges. That golden control mentioned earlier, most of the gold, so to speak, comes from fees. The pipe rolls, the crown's financial records, show a steady stream of revenue from writ fees and fines. Lose your case? Pay a penalty. Make a procedural mistake? Pay a penalty. Justice was monetized. The royal courts enriched the crown. But from this came a system with written precedents, with procedures, with judges who developed professional pride in consistency, with rules that, once written down and cited, became harder for even the king to ignore. You could see it in Glanville, the first great book on English law, written at the end of Henry's reign. It wasn't a grand vision of liberty. It was an employee handbook, a guide written for royal judges, written by the king's chief legal officer. Here's how to run a court. Here's how to issue a writ. Here's how to make the system work. Henry's system survived him. It survived his son Richard. But then came John. King John, Henry II's youngest son, came to power in 1199. Under John, the common law became a tool for abuse. John had lost most of his French lands and was desperate for money, so he raised taxes, and he raised them again. He charged his barons enormous fees, and he seized their lands without justification or trial. The barons had reached their breaking point. In 1215, the barons forced King John to agree that even the king must follow the law of the land. It is known as the Magna Carta, or simply the Great Charter. Over the next 4 centuries, the common law system grew under the shadows of the Great Charter. More courts, more judges, more precedents written down, and something unexpected, judges who developed loyalty not to the king who appointed them, but to the written decisions that came before. By the 1600s, Sir Edward Coke, as Chief Justice and the interpreter of English law, is telling King James I that the king himself is subject to the common law, and citing medieval precedents to prove it. The system Henry created to extend royal power became the system that limited royal power. And it was during this very era, while Coke was telling kings they were subject to the law, that English colonists began crossing the Atlantic. Gold, control, but eventually a system with some justice. That explains common law, but what about the doctrine that was used to dismiss the widow's case? The one that was applied by our courts as vigorously as it had been on behalf of the crown? For this, we have to turn to an English man whose book would become revered by the most powerful Chief Justice America ever produced, and how one passage from that English book quietly rewrote what all cases and controversies meant in the American Constitution. Before the Englishman William Blackstone was a famous author, he ran a paid lecture series in Oxford. Starting in 1753, students paid to attend, and the series brought him hundreds of pounds annually. But success bred a problem. Students took notes, copied them, and eventually sold them. By the mid-1760s, his lecture income had dropped sharply, so Blackstone pivoted. If his material was already circulating, he would control the definitive version. The first volume appeared in November 1765 and eventually earned him over £14,000. It was in this commercially motivated book that Blackstone transformed the maxim, "The king can do no wrong." Earlier jurists, like Bracton, had understood the phrase narrowly. The crown was not privileged to do wrong. Blackstone refused that constraint. In his commentaries, he wrote that the king was not only incapable of doing wrong, but even of thinking wrong. He could never mean to do an improper thing. In him is no folly or weakness. What had been a limit on royal power became a doctrine of sovereign perfection, and that was the version that found its way into American courts. But not at first. James Wilson was not born in America. He arrived in Philadelphia in 1765, a 23-year-old Scottish immigrant with a university education and no money. Within a decade, he would sign the Declaration of Independence. Within 2 decades, he would help draft the Constitution. Wilson came from a world of kings and parliaments, of sovereign immunity and crown prerogative. He knew what he was leaving behind, and in the colonies, he found something different already taking shape. When English colonists crossed the Atlantic, they didn't bring the king's courts with them. No writs, no royal circuits, no Westminster Hall. What arrived in their place was something new. Massachusetts Bay, 1641. The colonists had been demanding a written legal code for years. The magistrates resisted. They believed law should develop as it had in England, through custom, through judicial discretion. The colonists disagreed. Nathaniel Ward, a Puritan minister who had trained as a barrister, basically another name for a lawyer, submitted a draft. 98 sections. The Massachusetts Body of Liberties. Unlike English practice, cases would not be dismissed for minor technical errors. Provisions guaranteed speedy trial, protections against double jeopardy, limits on cruel punishment. At most, 7 of the rights in the Body of Liberties can be traced to English sources. 7 others originated in Massachusetts. England had nothing like it. Pennsylvania, 1682. William Penn, a Quaker who had spent time in English prisons for his beliefs, arrived with something called the Frame of Government. Penn created the first formal amendment process in history. In England, you could be executed for over 200 crimes. In Pennsylvania, the death penalty applied only to murder and treason. The colonists weren't rejecting English law entirely. They were adapting it, codifying it, making it work for communities that had no lords, no king. By 1776, the colonies had been building their own legal traditions for over 150 years. Written codes, simplified courts, protections that didn't exist in England. James Wilson understood this. He had chosen to go to America. He would help build what came next. And when the time came to decide what common law would mean in America, Wilson would argue for something the English version never intended, that the law binds everyone equally, including the sovereign. And one moment shows this clearly. And it actually only involved simple editing. Federal Hall in Lower Manhattan, spring of 1789. The first Congress had been in session barely 2 months. The new government was finding its footing, organizing departments, establishing procedures, figuring out how a republic actually operates day to day. Most members thought they had more important work than revisiting a constitution they had just finished ratifying. Then James Madison rose to speak. At 38, Madison was slight, soft-spoken, almost scholarly in demeanor. Madison had made a promise to Virginia voters, to anti-federalists who feared the new government, to his friend Thomas Jefferson, then serving as America's ambassador to France. He had promised to propose amendments protecting individual liberties. As he drafted these amendments, he faced a challenge. Which parts of English common law should the new American Republic keep? Which should it reject? And which should it simply leave behind? Madison drew from English legal history. The Magna Carta of 1215 inspired the right to trial by jury. This he kept. The Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved. And there was that word, common law. But not English common law, American. Regarding speech, Madison knew English common law contained something called seditious libel. Under English common law doctrine, you could be imprisoned for criticizing the king, even if what you said was true. Madison rejected it. He rejected it affirmatively. The First Amendment, Congress shall make no law abridging the freedom of speech or of the press. On another common law practice, a different path was made by Madison. The old English maxim, the king can do no wrong, Madison didn't mention it at all. Our government didn't have a king. And a court case involving a man's claim to a missing payment for a supply of handkerchiefs and blankets shows exactly what Madison meant and how the founders interpreted it. February 1793, Philadelphia. The Supreme Court of the United States heard arguments in Chisholm versus Georgia. A South Carolina merchant's executor was trying to collect a debt from the state of Georgia. Georgia refused to appear, claiming that they could not be sued by this individual. So the Supreme Court had to decide, does the Constitution allow a citizen to sue a state? Justice James Iredell said no. In his dissent, Iredell cited Blackstone extensively. The commentaries explained how English law worked. The king could not be sued. Sovereign immunity protected the crown. And the American states, Iredell argued, inherited that same immunity. Justice James Wilson disagreed. Wilson had been at the Constitutional Convention. He'd helped draft that document. He had chosen America, and in his opinion, he acknowledged Blackstone, but then he dismissed him. In England, according to Sir William Blackstone, no suit can be brought against the king, even in civil matters. But then Wilson pivoted. It was not always so. Under the Saxon government, a very different doctrine was held to be orthodox. Wilson went deeper into English history than Blackstone. He found a time when even kings could be called to account. And more importantly, Wilson pointed to something Blackstone couldn't address, the American Constitution. Article 3 extended the judicial power to controversies between a state and the citizens of another state. Chief Justice John Jay agreed. So did Justice William Cushing. So did Justice John Blair. 4-1. The side citing Blackstone lost. A citizen could sue a state. The sovereign was not above the law. 2 years after Chisholm versus Georgia, the states ratified the 11th Amendment to overrule that decision. Citizens of one state could no longer sue a different state. But the amendment said nothing about citizens suing their own state, and nothing about the federal government. So people point to the 11th Amendment as some sort of justification for sovereign immunity, when in reality, it's very narrow. That was the decision, but there was a voice missing from that courtroom. But that voice would make a lasting difference once it got there. In 1771, a subscription notice circulated through the American colonies. A Philadelphia printer named Robert Bell was offering the first American edition of William Blackstone's Commentaries on the Laws of England. 4 volumes, $8 for the set, far cheaper than the $26 for British imports. Among the subscribers was Captain Thomas Marshall of Dunmore County, Virginia. Thomas Marshall was a surveyor, a land speculator, a man of the frontier who'd built his family's fortunes in the Blue Ridge Mountains. He had 15 children. The oldest was John, a boy Thomas had decided would become a lawyer. When the volumes arrived in 1772, Thomas gave them to his 16-year-old son. John Marshall would read those volumes 4 times before he turned 27. Years later, Marshall would write of his father, "To his care, I am indebted for anything valuable which I may have acquired in my youth. He was my only intelligent companion, and was both a watchful parent and an affectionate friend." What made this book his father gave him so compelling? Order, clarity, system. The common law had grown wild and tangled over centuries, a maze of writs and precedents and customs that even lawyers struggled to navigate. Blackstone tamed it. He organized English law into 4 elegant volumes with clean categories and logical progressions. For a young man on the Virginia frontier studying to be a lawyer, it was a revelation. Here, finally, was a map of the law. But it was a map of England, not of America. This was 1772, before the Revolution. For 3 decades, Chief Justice John Marshall shaped American law from the center chair of the Supreme Court. Case after case, opinion after opinion, his father's book always within reach. By 1834, Marshall was in his final years on the bench. And within that final year, United States v. Clark came to his court. The case involved a Florida land grant. George Clark claimed 16,000 acres under a title from the Spanish governor, issued before America acquired the territory. The government disputed the grant. Marshall ruled for Clark. The land was his, but Marshall wrote something else in that opinion. One sentence, clear and direct. As the United States is not suable of common right, the party who institutes such suit must bring his case within the authority of some act of Congress, or the court cannot exercise jurisdiction over it. In plain English, you can't sue the government unless it lets you. He didn't have to write that. The case didn't require it. Clark won regardless, but Marshall wanted it on the record. Compare that sentence to Article 3 of the Constitution. The judicial power shall extend to all cases, to controversies to which the United States shall be a party. All cases, all controversies. The United States is a party, not immune from suit, but subject to it. Wilson read the Constitution and saw what it plainly said. The sovereign could be held accountable. Marshall read Blackstone and saw something else. The king can do no wrong. Two men, two views of what common law meant in America. Wilson's view carried the day in 1793, but Marshall had 3 decades to write a different story. By 1834, his view didn't need to win an argument. It just needed to be stated, and cited by others, and cited again. Eventually, the court found ways to hide the origin of what they were even doing. Marshall's sentence didn't stay in Clark. Courts cited it, then cited those citations. By the 20th century, judges no longer had to mention Blackstone. They had American precedent now. But people kept trying to sue the government, so the courts developed labels. For soldiers and their families, incident to service. For civilians, discretionary function. Different words, same result. The individual got their case shut down. St. George, Utah, the 1950s. 70 miles west, the government was detonating nuclear bombs. The fallout drifted over southern Utah, fell on farms, on livestock, on children. Residents remember it like falling snow. The Atomic Energy Commission promised safety. Their own scientists knew the fallout could kill. They said nothing. In 1954, a film crew shot The Conqueror outside St. George. This was a film where John Wayne played Genghis Khan. John Wayne is Genghis Khan. I haven't seen the movie, but I don't think it'll work. Regardless, by 1980, 91 of the 220 cast and crew had developed cancer. 46 died. They weren't alone. Leukemia clusters appeared in children. Thyroid cancer spiked. Over 1,000 downwinders were sick or dying. Government documents surfaced. One internal decision, not to test milk samples in order to avoid arousing public concern. In 1984, federal judge Bruce Jenkins ruled the government negligent. 9 plaintiffs won, but the government appealed. In 1987, the 10th Circuit reversed everything. The reasoning? Discretionary function. Every decision, how to monitor, whether to warn, was a protected policy choice. The decision to keep people ignorant? Policy judgment. Protected. The court wrote, "It is irrelevant to the discretion issue whether the AEC or its employees were negligent." Irrelevant. Then a judge admitted something unusual. It undoubtedly will come as a surprise to many that 200 years after we threw out King George III, the rule that the king can do no wrong still prevails at the federal level. The king can do no wrong. Still. Bernice Ferris, 1950. Husband killed by Army negligence? The court's answer? Incident to service. The Downwinders, 1987. Hundreds dying from radiation the government knew was dangerous? The court's answer? Discretionary function. Different labels, same doctrine. A federal judge said it plainly. The king can do no wrong. Still. The Downwinders waited until 1990, when Congress, not the courts, created a compensation fund. One of the victims wrote later, "In my 20s, I was diagnosed with thyroid cancer. On my hospital bracelet was a radiation symbol. I was a radioactive material. Tumors meant I never could have children. The Constitution promised access to the courts. English common law, filtered through Blackstone, inserted by Marshall, buried under labels, takes it away." To learn about other quiet mechanisms that can and often do impact your life, and not always for the better, check out my Plain Meaning channel on YouTube for more episodes. And if you watch them all, don't worry, because I release a new one every Tuesday.